Number 10, People v. Darryl Watts.
Good afternoon, Your Honors, and may it please the Court. Rachel Pecker of the Legal Aid Society. On behalf of Darryl Watts, I'd like to reserve 3 minutes for rebuttal, please.
Yes.
Holding Mr. Watts' SORA hearing when he was incompetent violated his due process right to be present and to participate at his hearing. An incompetent Mr. Watts could not effectuate any of the due process rights to which he was entitled, rendering them meaningless. Doe v. Pataki and Correction Law 168-0 lay out the constitutional and statutory due process rights to which Mr. Watts was entitled.
Does a modification pursuant to Paris, does that take care of a procedural issue here, do you think?
It does not, Your Honor, and I'd be happy to tell you why. That was one of the solutions that the Paris court provided for this due process problem here. And a 168-0 de novo hearing was essentially legislating from the bench. There they wrote in a hearing that does not exist in the statute and wrote it into the statute. And although they didn't admit that there was a due process violation taking place, it inherently recognizes that there was a due process violation there. And this court has recognized that a 168-0 hearing is not a replacement for a fair and accurate hearing in the first place and an accurate initial classification in the first place. A 168-0 de novo hearing also presumes that the initial level up front was correct. And here we know that it was not. The Paris and the Watts courts never suggested that Mr. Watts' participation didn't have an impact on his classification
what
level.
do you think, what do you
Yes.
think should happen here?
Great, Your Honor. So the rule that we're asking for today is if the SORA court thinks that there is indicia of incompetency, then they have a duty to inquire. And if it reasonably appears that Mr. Watts was incompetent, then they have a duty to order a competency evaluation. And that balance makes sense.
Okay, and let's play that out, though. Let's
Sure.
assume he's, in the meantime, what happens? This may take a long time to have not a long time, but some time to take get a
Sure,
competency.
absolutely, Your Honor. Do you want me to start with
So what happens in the interim first?
after he's been found, let's say he was found incompetent?
No, he hasn't been yet, but there's a hearing order.
Okay,
Or
all
an
right.
exam order, I'm sorry.
Sure. So the court orders an exam. If the findings come back that he is competent, the court
In the meantime,
If
what
you're
happens?
Sure,
waiting for a
yes.
finding, does he get released while you're waiting for a finding?
Okay, so if, in the meantime, what happens? So here, Mr. Watts was in confinement. He was civilly
But what
confined
if the
at the time
person
of his...
is not?
Okay, so why don't I go through all the situations? So if he was civilly confined, we would know where he was, and Mr. Watts was on PRS, so there's not that concern. I understand. If he was not confined, then what happens when he's in the community? The court would handle this just like it handles 730-20 misdemeanor out 730 cases, as this court considered in Molinaro v. Rikers. In those cases, when the court has a client that is entitled to be in the community, they order a competency evaluation, and the client is released and has to get to that competency evaluation.
So this person who could be, again, not a hypothetical, a level 3 override sexually violent offender is released into the community while this is happening?
Correct, Your Honor, and that makes sense because the legislature in the correction law has already contemplated for 3 situations like this where registration is required before...
Before we get,
Sure.
let's stop with that makes sense. So part of SORA is protection of the community, right?
Yes.
You have somebody who's subject to a mandatory override, let's say level 3 sexually violent offender, but pending the competency hearing, they're being released into the community.
Correct, and
Because
there's...
of a case that involves a misdemeanor and a competency hearing?
No, so the 3 ways, so the legislature contemplated that someone who perhaps the board is recommending a level 3 might be in the community and be registered but not yet have a level. That happens in 3 situations. So that happens under 168-L subsection 8 when a hearing cannot be held before the client has been released, and then the client has to register and they're released to the community, but they have not yet had their level. It happens in 2 other situations that the legislature already contemplated. It happens when an individual has a federal sex offense conviction and when an out-of-state sex offense offender moves into the state. They have to register within 10 days of moving into the state, but they don't yet have a level. And the legislature didn't say you can't live in the community without a level.
So would
They
your
under-
client be
Yes.
registered?
Yes, Your Honor. Here, Mr. Watts, by the time of his SORA hearing, was registered. And registration sufficiently on its own protects and furthers SORA purpose because
Registration, as I understand it, is
Sure.
kind of a level 1 light, right?
it has many of the same obligations as a level 1.
But not all.
But not all, correct. So registration, so SORA's purpose is twofold. It is to protect the public, and it does that by allowing law enforcement to monitor, identify, and apprehend individuals, providing a disincentive for them to recommit crimes, and also by providing community notification. Registration in of itself satisfies
But how
both
is
of those.
registration impacted by the level that you're designated?
Registration is based on your crime of conviction, and you have a list of things that you have to do.
But when you're designated a
A
certain
level, you get
level,
additional obligations and notifications.
and so if you're out and you, after a hearing, would be a level 3 and you're only a level 1, is the community being protected?
In this unavoidably imperfect situation, Your Honor, yes, you are, because registration in of itself requires that the registrant has to give his name, his picture, his identifiers, crime of...
If we followed your logic, then you would just say, all you need is registration. You wouldn't have the different levels. If registration took care of the concerns, as you said, then we wouldn't need to have level 1, 2, or 3, because registration would suffice.
So the
If
question...
we followed your argument to its natural conclusion.
No, Your Honor, respectively, no, Your Honor, because we're not asking for him never to have a SORA hearing. We're just saying that the SORA hearing can't take place when he's incompetent, because it's as if he wasn't there.
So registering him.
I assume there's-
Here. Oh, sorry, Judge Howland, go ahead.
No, I was just going to ask, I assume there's no limit on how long he might be in the community and incompetent. It could conceivably be years. Yes?
Correct, Your Honor. Here, just to reiterate, he was actually civilly confined.
I understand.
He wasn't in the
Yes.
community. It could be years, but I think another one of the cases right now that our appellate providers in New York City have addresses that issue, which is recently competency was an issue at a SORA hearing, and the defense counsel raised it. But then before the next adjourn date, the client was returned to competency, and so it became moot. And
But what happens if the client is not returned to competency? Is there a situation, a plausible situation where someone remains out, released, registered, a level 1 or a level 1 light, as it were, for years, even though upon adjudication, they might be a level 3?
Yes, Your Honor. I don't think that worst-case scenario, first of all, I don't think that worst-case scenario happens all that often. Following Lopez v. Evans, we know that in New York City, parole revocation and competency has only come up between 10 and 25 times per year.
What is the good that is served by your proposal of just having them register and wait for a competency hearing?
The good is that there's a due process violation that has occurred because a hearing was held when my client was present in body only.
And all the
when
due
this-
process protections from Dobie, Pataki, and the other cases, they simply don't adequately protect whatever the concerns are that you perceive flowing from this particular deprivation?
That's correct, Your Honor, exactly.
And how is that precisely?
Okay, of course. So my client lost every one of the due process rights that he was entitled to at his hearing. He lost the right to presence because he was present in body only and could not waive intelligently, voluntarily, and intelligently his right to
Did
presence.
he get notice?
He got physical notice. Whether he was aware of what that notice meant is
he get an
another
attorney?
question. He did get an attorney, Your Honor, but he lost the right to an attorney is only meaningful if the attorney can collaborate with her client, and his attorney could not provide effective assistance of counsel at the hearing here if she could not talk to her client about the facts of the case, his mental state at the time, his history and background, his family and friends, his subjective response to treatment and incarceration, his present thinking on the victim and his offense, any remorse, plans for the future, any number of things that a client could offer and provide to counsel that only he knows. And this court held in Rivera versus Superintendent of Woodbourne that ultimately at a SORA hearing, the court's determination depends on the unique circumstances and individual lived experiences of a registrant. And here...
Could the court, I'm over here, could the court, let's just go with your, what you say happens in the interim, if they're out, right? They're out in the community, they've had to register. I do want to hear actually what you say this registry component is, but in any event, could the court impose conditions while waiting for the results of a competency exam?
Yes, Your Honor. There's numerous, and I'll also then address your second question about registration. There are numerous options in our existing infrastructure to reasonably accommodate the registrant and for the court to decide what should happen and to give it assurance. And I'll step back and give you examples of what courts are already doing in these unavoidably imperfect situations to accommodate. So for instance, Your Honor, where there's no evidence that a client has gotten notice. The court says, okay, we can't go forward today. I'm going to ask the prosecutor to give me an update in, let's say, 90 days, whether there's proof that the client has gotten notice, and it's put over. A second case recently is that a client's SORA hearing was scheduled. He lost his good time, and so now we thought he was being released, but he's not going to be released for 6 more months. The SORA court says, okay, even though we don't expect him to be released for 6 months, I'm putting this on the calendar for 90 days. At that point, I want an update from both the prosecution and defense counsel.
I'm sorry, but my question was what other, if any, conditions could be imposed to address the concerns about the purpose of SORA and public security?
Got it.
And
Yes,
safety.
Your Honor. So the court could say, I would like, in the interim, I'd like to follow this this registrant, and I'd like the court and defense counsel, the prosecutor, to check in 90 days. And the fiscal, I guess I was giving the other examples to Your Honor because the fiscal and administrative burdens of requiring competency are not so prohibitive or different or significant that what courts are already doing. And so, Your Honor, going back, why it mirrors the 730-20 context is if the court were to say, I'd like to see the client back in 90 days, at which point he may or may not be competent, we both know the client may not be competent but able to get himself to court. The legal aid, the defense lawyer might be able to help him to get to court, or if he has OMH wraparound services, as Mr. Watts did for the brief period of time that he was in the community, a caseworker, an independent living specialist could facilitate him getting back to court. For someone on PRS, parole release supervision, the parole could also make a condition to abide by the court's rules. So if you don't show up to court, it would be a violation of his parole. Your Honor asked about registration. So registration in of itself requires that the person register with their information, their crime, their identifiers, and their account, internet account within 10 days of setting up residency in the state.
With whom?
Sorry?
With whom?
With
Local precinct, with
DCJ,
what? Okay.
DCJS.
On the registry, okay.
Yes, on the registry.
Got it.
They have to annually verify their address. If they move, they have to verify their change of address within 10 days. They have to register for 20 years. And as it goes to the notification concern, they also are included in the 1-800 notification
I see.
analysis.
They're not on the website.
They're not on the website, but as a level 1, the best that an individual could do at a hearing, they also wouldn't be
Yes.
on the website.
Yes.
So here, whatever half measures Mr. Watt's counsel could cobble together, there was no serious dispute that an attorney who cannot collaborate with her client was hamstrung. And here, there was ample evidence before the court that Mr. Watts was not competent. No one, not the court, not the prosecutor, argued that he was competent. The court had both record evidence before it as well as its own observations and counsel's representations. He had been 730'd for 5.5 years. He was then found fit for a quick moment in time.
Counsel, can I ask you a very hypothetical sort of question? In the civil context, when some litigants are facing negative consequences as a result of litigation, an eviction or something where they might lose property or liberty, the court can appoint a guardian for them who stands in their shoes during, and they're deemed to be, not able to contribute to their own defense. The court can appoint a guardian to make those sorts of decisions. Do you think a solution like that might be viable in this context so that you don't have to have this sort of indefinite waiting period?
I don't think so, Your Honor, and that's because a guardian or counsel can step in and suffice when the question before the court is one that is a matter of law. What can the client contribute at a certain kind of determination? If the answer is nothing, then counsel or guardian might suffice. And I think looking to the civil procedure, administrative proceedings that my adversary pointed to.
How do you determine when you say contribute nothing, then it's okay? Like with an Article 81 proceeding, there are times when they can't provide information. So the guardian is put in their stead to be able to communicate with the lawyer. They get two different people performing different functions.
Right, so I'll answer both of yours. Let's take Article 9 and 10 is what proceedings. So those proceedings, unlike our proceedings, are not merely sanctions to prevent future recidivism. There, the court invokes its parens patriae power, and the legislature created those hearings out of their care for individuals who cannot care for themselves. And this court recognized in State v. Floyd that those litigants, while they may be able to contribute information that is the beginning of an inquiry in Article 9 or 10 proceedings, in the end, the legal determination being made in Article 9 and 10 is going to be a battle of a battle of psychiatric experts. The decision will come down to whether he has a mental illness and whether he meets the criteria for 9 and 10. And so that is a matter of law, just like this court is considered in People v. Roman. If it's a matter of law that the registrant, the litigant, has nothing to contribute to, his presence isn't necessary. And the termination of parental rights is another example, Your Honor. There, again, the state is invoking its parens patriae power because it's specifically concerned with the best interest of the child. There, too, the legislature, which it has yet to do here, specifically contemplated what should happen in this imperfect situation, what processes do when someone is incompetent. And there, it simply just cannot be that a parent could say, I'm too incompetent to have a hearing, but not so incompetent that I can't be a good parent.
But the benefit of that sort of arrangement, and I hear what you say about how it isn't going to work, is that you always have competing interests. You have the interests of the person who's being negatively affected, and then you have the interests of the child, or you have the interests of whoever's on the other side of the litigation. And here, we're talking about the interests of the community at large, which, by your solution, sort of have to wait indefinitely to get vindicated pending a return to competence. And that seems to, among other things, it seems to really be very inefficient.
I think I understand the concern that Your Honor has, but I think that it loses the understanding that some states have a SORA statutory scheme that is just registration based on past crime, and we don't have that. So our state has a 2-level, and our legislature understood that registration in itself provided law enforcement with information and provided basic notification for these imperfect situations before a level can be held. And I think it's just not that common that it will be indefinite. Again, it's not that he doesn't have to register. It's just the SORA hearing can't happen yet.
But he's not registered as a level. So level 3 has very strict requirements in level 2 as well in terms of public notice, right? You can go on the website. And it seems we're very much downplaying the public safety when you say kind of no harm, no foul. He has to register, and some states do that. Well, New York's decided not to do that. And let's say this is a level 3, would be a sexually violent predator, child sex predator convicted, looking at a violent sexual level 3. Under your regime, they go out indefinitely. They have to just show up and register, but they're not on the public website. And here's a family who has a child that is going to go door to door to sell things. And they're responsible. They go on the website and they want to make sure this child goes out, they're not knocking on the wrong door or at risk. They go on, they don't see this person because they don't have to be publicly registered. Isn't that a public safety impact?
Your Honor, it's only a windfall to the registrant in the way that I think you're suggesting.
I don't think it's a windfall to the registrant or not. I think it's a problem for the community.
I
I'm
think
putting
when we,
aside the interest of the registrant right now, because this is not only about the registrant.
right, but I think that hypothetical presumes that a level 3 is correct. And if our client wasn't at the SORA hearing, we just don't know if a level 3 would have been correct. And this
But let's
court,
even say he was a presumptive 3. You don't think that in a SORA hearing, it would at least be a 2? So they would have to publicly register? That it could be a 1, is what you're saying.
I think that when you take into account the Matthews v. Eldridge factors, the due process violation here, this court hasn't imputed a prejudice analysis. And so I understand that that the court has concerns. What if this person had been a level 3?
But there are different interests here. We're not only
Correct.
looking at the registrant here. It's a civil proceeding. It's not a criminal proceeding. They're not going into incarceration. We've said it's a civil proceeding, and there's a public safety component to that proceeding, just as there's an interest of the child component in other
Correct.
proceedings. So we have to weigh that, and I don't see how your solution factors in public safety.
So, Your Honor, one, I understand that we disagree. I think registration does factor in public safety. But two, Your Honor, this court has also recognized that the state has an interest in a classification system that is fair and accurate. And in comparing this, you said that it's a civil proceeding, which it is. But in Lopez v. Evans, this court considered only secondarily that the possible reincarceration of a parole violee was a reason for the due process rights and for competency to be read into that proceeding. What the court said in Lopez v. Evans was that its primary concern, its quote, paramount concern, was the fairness and the accuracy of the proceedings. And this court in People v.
That
Mingo...
parole violator is facing prison time,
Correct.
right? To me, the analogy is imposition of parole conditions. What if a person shows up at a parole, they're eligible for a parole, and they show up and you say, I can't understand the nature of this proceeding, so you can't put any additional parole conditions on me. That's what this is more analogous to me. This isn't a SORA violation proceeding.
Respectfully, I disagree, Your Honor. Our clients don't have a right to counsel or these other due process rights with their parole officer. I'm not, as his counsel, I'm not present in those situations. At his hearing, he has a right to counsel and all of these due process rights that only he had information in his head that could have persuaded the court of what the right level was in this proceeding.
Could the court, since I asked you before about additional conditions, could the court, I'm trying to follow up on Judge Garcia's very valid concern that he's discussing with you, could the court order that the individual, in this interim period, that the
Yes.
individual be placed on the website?
I don't know the answer to that question, but parole can. Parole can set a condition sets its own conditions of, special conditions of parole. And if that's what the court was concerned with, yes, they could do that. But I think a level 3 doesn't give that much more information to law enforcement to be able to identify, apprehend, and...
No, but this was an issue
Yes.
about access for the public to information so that the public can take whatever action the individuals deem necessary to protect themselves and usually young people, right?
Correct, Your Honor. Going back to Judge Garcia's questions about, parole being different, I would say that while it's true that parole is the closest analog to a criminal prosecution, I still think the commonalities between a SORA hearing and a parole hearing and the parallels and the serious deprivation of liberty at a SORA hearing make it the closest parallel and helpful analogy. And that's because even though the possibility of incarceration following a parole violation occurs, there are 4 consequences as great in the SORA hearing or analogous. Your Honors, hundreds of registrants remain incarcerated because of their SORA level or SARA being applied as habeas petitions in this court and throughout the state demonstrate. Also, the possibility of prosecution for a SORA violation is not speculative, as my adversary suggests. On a yearly basis...
Maybe you couldn't adjudicate the violation if you were incompetent, because then you would say, I didn't understand, and I didn't understand I was violating. And that would be analogous to your parole revocation.
That would be a mens rea defense at that time, you're right, of the prosecution, Your Honor. But it's a prosecution that hangs over the individual's head because they were subject to a level at a hearing that it was as if they weren't present at the hearing. And I think in Doe v. Pataki itself, the court said that the consequences of notification and registration are significant enough that the closest parallel it drew was to parole. It relied on Morrissey v. Brewer and said, let us look at the reasoning that the Supreme Court decided what due process protections are due in parole, and that reasoning is the same one we're going to use here to decide what due process rights
So
are.
Mr. Watts was registered while not competent.
Correct, Your
And I
Honor.
take it you think that is not a due process violation because the Matthews factors balance differently?
We're not challenging his registration here, and that's...
Well, I understand that, but I
Yes.
asked you something a little different.
Yes, and the answer is, I don't even think, I guess, we don't get to the Matthews factors, I think, because registration happens as an automatic and mechanical result of his criminal conviction and his certification at sentencing, and at the time he registers, he doesn't have a right to counsel. What can he contribute to whether or not, as a matter of law, he has to register? Nothing. What can he contribute at a SORA hearing under the second tier of New York's statute? Potentially everything. His
Yeah,
participation
but some of the
is
SORA,
vital.
would you agree with me that some of the SORA qualifications are static? Or you could figure it out from the nature of the crime or from, the person's background? And what if, based on the static information, you come up with a level 2? Why
So-
then would
sure.
it be inappropriate to render that classification?
So some are static, Your Honor, but there are 15 risk assessment instrument factors. 7 of them are not static.
Okay, but going back to what I'm saying, what if the static ones get you to a level, and then we have the Paris solution, which says the burden is still on the people, but you can modify? Why doesn't that take care of your issue?
Because I believe that that remedy, it's as if what you're saying is, the legislature said if there's no disagreement on the person's level, no hearing needs to be held. Or if everyone agrees that they're a level 1, no hearing needs to be held. But there isn't a sliding scale. The legislature said regardless of level and regardless of whether the parties agree, he has a right to a hearing and a
He's
right,
going to have a hearing.
a right to a hearing at which he was in all essence not competent.
The legislature put in certain factors that can get you to a rating without his involvement. If we looked at it from that perspective, so the legislature has taken care of that issue for us. Or sometimes they allow a judge to override, and if an override gets you to a 3, the input of the defendant is insignificant.
I disagree, Your Honor, because even if we were saying that his risk assessment instrument included only static factors, which here they didn't, risk factor 7, had he been competent, he could have provided information to his counsel to contest the prosecution's clear and convincing evidence on risk factor 7. But even if we had only static factors in the risk assessment instrument, as the court has recognized, the downward departure is a huge part of this process, and his not being present at a downward departure is the difference between a level 1 and a level 2. Even if Mr. Watt's points had been a level 2, if he could have contributed things, if he could have made sincere expressions of remorse and explained what happened in his illness, what happened at the time, why this was an anomaly in his life and what he has in the community, that could have been a difference between a level 1 and a level 2.
Yeah, I understand your argument.
Yeah.
I'm just trying to get at why Paris doesn't balance both your argument and the public safety concerns.
Going back to the fact that in other violations of due process in the SORA hearing, our courts have reversed, I think the court's decision in David W. is helpful, because there the court said, the question before the court is not whether David W. was accurately decided a level 3 or not. The question is whether he had a notice and an opportunity to be heard, and the same is true here. The question is not, regardless of Mr. Watt's level, it's not whether it was, had he been competent, whether he would have been a level 2. It's whether he had a meaningful hearing at a meaningful time and place where he could participate. And I think...
So it's not meaningful if he's not competent to participate. That's essentially your argument.
Absolutely, Your Honor.
Thank you,
Correct.
counsel.
Thank you, Your Honors.
Good afternoon, Your Honors.
Why is it that it's meaningful due process if one is not competent to assist their counsel?
Well, as a preliminary matter, Your Honor, there was no finding in this case that Mr. Watts was incompetent. But beyond that, there would be no basis to conclude on this record that counsel wasn't able to meaningfully protect his interests. For one thing, the entirety of the risk assessment was derived from static factors in this case. The nature of the crime, the fact that the defendant caused injury to the victim, the age of the victim.
What about the argument regarding the downward departure factors?
Sure. Counsel's main argument in support of a downward departure was the defendant's mental state. However, as Judge Kiesel noted, the defense counsel proffered no evidence with respect to his existing mental condition at the time.
What the question here, though, really is he made a request, or his counsel made a request for a competency hearing. So why shouldn't that have been granted? Why wasn't that error?
Because the existing safeguards contained in the statute are sufficient to protect registrants' rights, Your Honor. Competency has never been a constitutional prerequisite.
Right, so then to where you started was, well, there was no competency determination made here, so really that's irrelevant, right? Because you're saying it doesn't matter whether he's competent or incompetent. The reason to deny his request for a hearing was it makes no difference legally.
Correct, Your Honor. Correct, Your Honor. I was just pointing out as a practical matter that there had been no finding.
But that's inconsequential, right?
That's correct, Your Honor. It is inconsequential. It's not an issue that the SORA court was required to parse, because consistent with the civil nature of the proceeding. It was designed to advance the government's, the society's overriding interest in keeping the public safe from the risks of recidivist conduct presented by known sex offenders.
So why can't we just
Counsel-
hold all SORA hearings in absentia?
Because that would be inconsistent with the statutory mandate, Your Honor. It would hinder the public's access to information in this case.
Oh, I'm sorry, I'm asking about a constitutional question. Suppose the legislature rewrote the statute so defendants didn't have a right to be present. No defendant, competent or otherwise. Mm-hmm. Why that's okay? Doesn't violate due process?
If there were no competency requirement, I'm sorry, I'm not following.
Oh, no. If a competent defendant,
Right.
If the statute were written so that a competent defendant had no right to be at the SORA hearing, does that violate due process? Because when you say that the competency of the defendant doesn't matter at all, then I wonder what's the point of the defendant being there?
Right.
Why isn't that perfectly okay and not a violation of due process?
Well, I believe that the civil nature of these statutes have to merely afford the defendants a right to be present, to present evidence, to cross-examine witnesses. These aren't on a constitutional level with the rights that would of course apply at a criminal trial.
Counsel, this defendant, over here, if I can, counsel, thank you. This defendant was in OMH custody, is that right?
Correct, Your Honor.
So if we look only at individuals who are in OMH custody, not individuals who are currently in DOC's custody, what exactly is the state's interest in having a designation at that juncture as opposed to at whatever time, having a hearing at whatever time they're released from OMH custody? Because they're not out in the community at that point, I take it.
Absolutely, absolutely. So in that instance, it would still hinder the public's access to information, specifically those individuals who are likely to come into contact with him. And those.
You mean folks at the OMH facility? I would think there would be sufficient safeguards in place at a facility like that they would be able to handle that.
That certainly could be the case, Your Honor. I would just point out that there were no arguments made at the SORA court regarding the conditions of Mr. Watts' commitment, so we don't really know much about his placement.
But in terms of the Matthews versus Eldridge calculus, right? Could that come out differently with regard to defendants who are in OMH custody as opposed to not in OMH custody because the extent of the state's interest would be different?
I think conceivably the state's interest might be somewhat smaller in that circumstance, but it would still require this court to draw an arbitrary distinction and find that people who the defendant is going to encounter, visitors at the facility, other patients, that these people are somehow less deserving of protection than the public at large. And the statute...
Well, but it would presumably address or significantly mitigate the concern that Judge Garcia was raising about, for example, the child out knocking, selling candy door to door.
Right. It would address that aspect of his concern, Your Honor.
And is there a practical reason why you couldn't do that? Why you couldn't hold a hearing before someone is released from OAH custody?
Well, the statute required that the process for the SORA adjudication be set into motion within 30 days of the defendant's release from a correctional facility.
Well, it doesn't say that, does it? It says correctional facility? Doesn't it have a whole list of other things, like hospital?
It does say hospital, Your Honor, but and it's interesting you bring that up, because based on my reading of the statute, I'm not entirely sure that Mr. Watts' hospital meets the SORA definition of hospital. The definition under SORA of hospital contemplates two situations. One, where the inmate is confined pursuant to Article 10 of the mental hygiene law, and two, when the mentally ill individual is still a prison inmate completing his sentence and he has been transferred to that hospital. Mr. Watts completed his sentence. So I don't even believe that there is any sort of securing mechanism to even alert the board, the SORA court, the district attorney's office about that Mr. Watts' release is imminent.
Counsel, I don't know much about Article 9 and placement, but is it possible that the designated offender level would affect what type of facility a person is placed in OMH custody? Like if you're a sexually violent offender, you might not get placed in a less secure facility or get less privileges in terms of being able to go out into the public than you would if you were not designated a level 3? I mean, I don't know the answer to that.
I don't know the answer with certainty, Your Honor, but I think it's fair to assume that some decisions are determined based on facts and evidence that are reduced at the SORA hearing that alert the facility of a particular need to place
Unsupervised visits into the community.
Correct, exactly, Your Honor. And if I may, I just want to briefly address the argument that registering an incompetent sex offender elevates the risk of prosecution. I think that's a bit of a canard. An unclassified offender is still subject to the requirements of a level 1. So forestalling the SORA hearing indefinitely would not immunize Mr. Watts from prosecution if he didn't comply with the foundational registration requirements. And I would also just add that, of course, it's certainly within this court's province to disagree with us, to continue with its tradition of providing more protective rights under due process to criminal defendants. But I would just note that the natural corollary of such a rule would be an extension of this competency requirement to other civil proceedings that serve a non-penological purpose where even greater liberty interests are at stake. So that would be the path that the court would be embarking upon if it were to recognize such a right in this proceeding. Unless the court has any further questions, we would just ask that the order of the SORA court and the appellate divisions be affirmed.
Thank you.
Thank you.
I'd like to correct some errors I believe my adversary made and then answer Judge Halligan and a question by Judge Garcia. First of all, Your Honor, there was no dispute below that Mr. Watts was not competent or certainly had all indicia of not being confident. To Your Honor, there was a risk factor here, risk factor 7, that we regularly argue against all the time based on our client's input, so it was not all static factors. 3, registration is not the same as a level 1. They are similar, but level 1 imposes additional obligations on top of registration. I'm happy to expound on that if you would like. Turning to Judge Halligan's question, no, there is no reason why a hearing could not be held at a time when Mr. Watts was actually released into the community. Here, he was transferred directly from DOC's custody to OMH custody. And while it is true that there is a question whether South Beach Psychiatric Facility, where he was being held, was a hospital under the definition of the correction law, it is not true what my adversary said, that there is no alert mechanism to alert the court. 168M, as Judge Wilson noted, says any correctional facility, hospital, or institution shall forward information on the individual to be released within 120 days, and that sets in motion the same thing that happens when an individual is being released from DOCs. The board notifies the court.
So just to make sure I understand that,
Sure.
It sounds to me like what you're saying, but I want to make sure I'm hearing you correctly, is that there's, setting aside the hospital institution category question, there's nothing that you see with respect to the timing requirements for either reevaluation or release from OMH custody or the process for getting the SORA hearing in place that would preclude scheduling a hearing before someone is discharged from OMH custody. Is that right?
That's correct, Your Honor. The same mechanism that we go forth that the board then has a duty to inform the court informs the sex offender and the DA, the hearing is held, et cetera, gets put into place if his South Beach Psychiatric Hospital is included in institution or hospital. Going back to, and also to address Judge Garcia and Judge Halligan's question, the OMH facility manual QA-410 also puts in place that OMH gets a full criminal history and psychiatric and hospital history on anyone in its midst. And so yes, they regularly, within 24 hours of admission to an Article 9 facility, are making an analysis of where that individual should be housed based on his criminal proclivities, which the registry, they're not looking to the registry, they're looking to the official documents that they've received. And so they have all of this information at their fingertips.
Court determination that they were a level 3 sexually violent offender might affect that decision?
I don't know that it would, but I know that they have more information on Mr. Watts than a SORA hearing court does.
There was a mention in your brief I was going to ask about that if I want to mischaracterize it, but I think it said, as I remember it, it said that the level 2 designation might interfere with the ability of Mr. Watts to get services from OMH.
And that has happened here, Your Honor.
Can you explain that?
Sure. I don't think, I hope I didn't say from OMH, but for OMH to do its discharge planning and decide what is right, the level 2 has hampered him as a fact here. And that's because he has now been in Article 9 he was in Article 9 for over a year, he was released with full wraparound services, continually hospitalized, and now has been back in Article 9 involuntary civil commitment for over a year and a half. And it is my understanding from his mental hygiene legal services attorney, as well as his social worker, OMH social worker, that they have been unable to find him a nursing home, which is what the doctors think is the best place for him now. And a level 2, is their understanding, is part of the thing that is preventing them from implementing the discharge plan they deem best.
Doesn't that go to the point of they factor in the level in certain decisions of who you would have contact with? Because otherwise, why would it affect that?
Because nursing homes and OMH facilities are contemplating people's criminal proclivities already, and he has not sexually reoffended, Your Honor.
No, but I thought your point was because he's labeled at level 2, it's affecting where he can be placed.
I think in part it is, Your Honor.
Isn't that sort of the point of SORA, that these level designations might restrict that, given the risk?
That's correct, Your Honor, but it goes back to the fact that in this case, he was given a level at a hearing that he had a right to participate and a right to be present at, and he simply wasn't present. And just going back to Judge Singus's one question, although it's a second department case, I think People v. Gutierrez Lucero is a helpful case for this court to look at, because there was no question that the SORA registrant had not gotten notice, but he'd been deported. And so the question was what to do. And the SORA court said, had he done the best he could at a hearing, he would only have gotten a level 1. And so we're going to make him a level 1. The appellate division reversed And the appellate division reversed because they said the legislature did not put a sliding scale in place. It's all or nothing. He had a right to a hearing and to be present at that hearing. And the due process violation here occurred whether or not his level was correct. And I think that's the same thing that we're looking at here. He had a right to a hearing. He was not present at that hearing. And because the legislature and the Constitution, going to your question, afforded him due process rights at a hearing, our courts cannot withhold those rights by allowing SORA hearings to go forward when our clients are incompetent and not present.
Thank you.
Thank you, Your Honors.